Okay, welcome everybody to CJL2000, Law and Legal Process. My name is Shane Nelson, and I'll be your professor / instructor throughout this semester. I'll be guiding you throughout the course. Maybe you guys clicked on this video because you just have a general interest in law. Maybe I'm forcing you to because you're taking my class. But in any case, we'll be examining the foundations of the American legal system throughout this semester. We're going to be looking at a lot of things like constitutional rights, criminal and civil law, judicial decision-making, and many of just the major legal principles that shape modern society. So one of the goals of this course is not to simply just memorize legal terminology or case names. We're really trying to hope to just develop a broader understanding of how law operates in everyday life, how the courts influence our broader political systems, constitutional issues within the United States. And so throughout the semester, we're going to be analyzing many different real Supreme Court cases, contemporary legal controversies, and of course, ethical debates involving law, justice, and governmental authority. And before we dive in, I would encourage everybody to approach the course with curiosity and critical thinking. Many of the legal questions we're going to be discussing throughout this semester don't have any simple objective understanding. A lot of this stuff is subjective and not universally agreed upon. So I think this is part of the reason what makes law so interesting. So without further ado, let's get into this. So what is law? Well, if you guys have purchased the textbook by Schubert, which you should have by now, you've noticed that one of the major themes emphasized by Schubert is that law is not simply a collection of rules, but it's a structured system that's used to regulate our behavior, resolve disputes, and maintain our social order. Naturally, the law affects nearly every aspect of our society, and this is very much true even if people don't immediately recognize this. Also, if you look to our supplemental reading by Dr. Joseph Rivera, it's very much stated that legal disputes are often not simply about who is morally correct. There's a lot of things that are constitutional that both you and I might not agree with. But the law is simply more so about how courts apply legal principles, and they do so with these different factual situations. But by the end of today's lecture, you guys should understand the basic purpose of law, the major sources of law, and the role the courts play within American society. So, why do societies create laws? Well, the law serves several major purposes: maintaining social order, resolving disputes, protecting rights, preventing harm, and promoting stability. Now, as a society, we create laws because larger groups of people, the masses, they require systems of order and predictability. Without the law, many disputes, and this is definitely shown throughout history, have been resolved through means of force, intimidation, or even just personal retaliation. And Schubert explains to us that one of the core purposes of law is maintaining that social stability. We need to balance social stability with individual freedom and collective security. So for example, some criminal laws prohibit harmful conduct such as like theft or assault, and then we have different civil laws such as tort laws that provide mechanisms for resolving disputes between individuals, companies, or organizations. And I think it's paramount importance to just note that the law is definitely reflective of a certain value of a society at a given point in time. If you look at cases like Obergefell v. Hodges, which we will be going over later in the semester, there are certain things within society that they will choose to criminalize, regulate, or protect, and that definitely reveals things about the broader cultural and political priorities at that point in time. So diving into general definitions of law, the law can generally be defined as a system of rules enforced by governmental authority. And unlike many of the informal social norms or customs that we have, the laws are actually backed by institutions. So the institutions have to be capable of imposing the penalties or consequences for different violations of the law. Think of it this way: if the government had no real enforcement mechanism, then what would stop people from breaking the law? Schubert emphasizes that the law differs from morality, even though these two concepts can overlap at times. Once again, the law can still be immoral without being illegal. And vice versa, the law can also be legal while being viewed as maybe unethical or barbarous by certain portions of society. Think capital punishment, which has been a moral and ethical quandary for many decades now, but still this is constitutional in many different states. Although with the Eighth Amendment, many people would also state that this is perhaps cruel or unusual punishment. But this tangent aside, many of the key characteristics of the law will include rules that are enforced by your government overall, authority and legitimacy, broad application to society, and the punishment for sanctions and violations. So the distinction between law and morality creates many different important debates within the legal system. You guys will see this when you watch the episode 1 of Death Note Rebirth, which I've assigned for you. Again, more of a moral ethical quandary. But as our society evolves, the courts are frequently asked to redetermine not simply about just how the law is fair, but what is more so legally permissible under the Constitution, statutes, and precedent. So moving into the major types of law, the American legal system contains multiple different categories of law which each serve different purposes. Criminal law is probably the one you guys are most familiar with from pop culture alone, but the government prosecutes individuals accused of violating criminal statutes. So punishments may include different fines, probation, or imprisonment, such as jail or prison. Civil law generally involves disputes between private parties, and some common examples of the civil breach of contract. Common examples of civil law would be things like breach of contract, negligence, personal injury claims, or property disputes. Constitutional law focuses on the structure of our government and the protection of the individual rights under the Constitution allowed to us. And we have different administrative laws which govern regulatory agencies, such as like the EPA, Environmental Protection Agency, or the FDA, the Food and Drug Administration. And Schubert explains how many of these areas often overlap with one another. For example, a single event might produce both criminal liability and civil liability. One famous example of this was O.J. Simpson. While he was found not guilty under the criminal law, in civil law, he ended up having to pay quite a hefty amount. So where does the law come from? Well, the law is derived from Old English common law. One of the more important concepts in American law is that legal authority comes from multiple different sources simultaneously. The first major source is our Constitution, which serves as the supreme law of the United States. Constitutional provisions establish governmental powers and protect individual liberties. Now, the second source is statutory law. Legislatures pass statutes at both the federal and state levels. The third source of law is created through precedent by judicial decisions. Under common law systems, prior court rulings influence how future cases are decided. And lastly, administrative agencies can create regulations that carry the force of law. Schubert discusses that understanding the hierarchy of legal authority is critical because conflicts sometimes arise between statutes, constitutional rights, and agency regulations. So just remember that the courts are frequently required to resolve all of these conflicts. Now, our courts have several critical roles within our legal system. First and foremost, the courts have to interpret the law. Judges often must determine what the statutes or constitutional provisions actually mean when you are applying them to a specific dispute. So the courts have to resolve different disputes between individuals, organizations, and sometimes government actors. The courts have to protect constitutional rights by limiting unlawful government action. They have to review governmental conduct to ensure compliance with constitutional principles. So in the book, you'll notice that Schubert repeatedly stresses the importance of judicial legitimacy. Schubert is more so imploring us to understand here that the court possesses not really any military power, nor direct enforcement authority. So a court's legitimacy depends heavily upon the public trust in the fairness and neutrality of our overall judicial process. So you think about the Supreme Court justices and their overall approval, right? Because there is no enforcement mechanism, we are relying specifically on their judicial legitimacy. It is of paramount importance that the court seems to be legitimate and fair throughout the judicial process. This is, of course, becoming especially important in different constitutional cases where the courts are asked to invalidate laws that have been passed by just our elected officials. So I would like to just note all of that. And there's actually an interesting quote here that I think you guys should know as well by Sebastian Junger, stating that, "I think that objectivity is like this strange myth that people think you're supposed to achieve, but actually, the dirty little secret is that it's not attainable any more than pure justice is attainable by the courts." A little tangent, but more for you guys to stew upon here, because I think it's just something you guys should mull over when addressing what the courts do and their overall legitimacy. Okay, so moving into precedent and stare decisis. Stare decisis is Latin, so who's to say that a dead language isn't useful? Stare decisis means essentially that you are treating cases the same or similarly. One of the more defining characteristics of our American legal system is reliance on precedent. So again, treating cases the same. The doctrine of stare decisis, boiling it down to its essence here, letting the decision stand, and how courts will often follow these prior rulings of other cases when you have a similar legal situation arising. And precedent builds. Precedent holds meaning. And our system overall promotes this level of consistency, predictability, stability, and fairness. Or so you would hope. Schubert explains that precedent allows for individuals and institutions to better anticipate legal outcomes and their structure and their behavior accordingly. But with this said, precedent is not absolute, and the court will sometimes overturn earlier decisions when societal values, either constitutional interpretation, whether they are originalist viewpoint or it's legal reasoning that will change over time. And when precedent is overturned, this will lead to landmark case decisions such as Brown v. Board of Education, which overturned Plessy v. Ferguson of the separate but equal doctrine. So you will have instances where precedent is overturned. Now, as I said regarding the Plessy v. Ferguson case, I think it's important to note that the law evolves over time. Society values evolve over time. and the law reflects both society and it shapes society. So as social values evolve, legal systems often evolve alongside them. Major legal changes involving civil rights, the voting rights, marriage equality, and things like criminal justice reform demonstrate how the law in our society change over time. So think about how legal decisions themselves can influence both public attitudes and political movements. Schubert discusses how courts become central actors in both broader social and political conflicts. Legal disputes involving equality, liberty, and governmental power often extend far beyond the courtroom itself. And I think this creates an important question for this course. Should the courts merely reflect our existing social values, or should the courts actively shape social progress? One of the central purposes of the Constitution is to limit governmental power. Constitutional protections exist because the framers recognize the dangers associated with unchecked authority. Our key constitutional concepts that you should remember include due process, equal protection, freedom of speech, protection from unreasonable searches, and the right to counsel, and we'll be diving into all of these in depth throughout the semester. Now, Schubert emphasizes that constitutional law constantly involves balancing individual liberty against governmental interests such as the public safety and national security, and many of the major Supreme Court cases arise precisely because this balance is hard to maintain. So the courts are frequently asked to determine whether the governmental's actions exceed constitutional limitations and authority. Okay, so in closing, today's lecture introduced several different foundational concepts that are going to remain important throughout the semester. First and foremost, the law exists to maintain social order and resolve disputes. Second, the law comes from multiple different sources, including our Constitution, statutes, courts, and administrative agencies. Third, courts play a critical role in interpreting and applying the law. Finally, constitutional rights play an important role in limiting governmental power. And as we move forward in the course, we're going to continue to apply these foundational ideas to real court cases and contemporary legal controversies.